Hello. In this clip from our Justia webinar, Unlocking the Potential of Non-Stenographic Depositions and AI, Charles Peckham and Carl Seelbach guide you through the history of testimony capture and how technology plays a role in legal issues like depositions. Remember, if you'd like to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Nina, thank you very much for that warm introduction, and thank you to Justia for hosting this. We really appreciate it. Okay, well, Nina was very nice to actually do an introduction. Sometimes hosts don't, so thank you so much. Well, we will not cover any of the legal or boring stuff. Charles, maybe let's briefly tell them something that they wouldn't find on our resume.
Sure. Sort of an interesting one. I graduated from the University of Texas at Austin, so I'm a orange-blooded Longhorn. However, I am married to an Oklahoma Sooner, and I have triplet children, all of whom are Aggies. So now the SEC football season is quite something for us. That's really the only interesting thing I have to say.
Okay, the only thing that I'll add for me is if I sound a little hoarse in my voice, it's because I was cheering at my 13-year-old's volleyball game last night. So it was a big match against one of their district rivals, and we won. So that was exciting as well. But that's pretty much what I'm doing when I'm not practicing law or helping with the legal tech company Scribe. I'm probably at one of my kiddos' sporting events, either volleyball or basketball, which is a lot of fun. So we'll just dive right in then to what we're really here to talk about, which is a new way to capture testimony. And before we talk about the solution, let's talk about a little bit about the history of how we've done it as a profession and as a society. Historically, we've captured testimony in a couple of ways. If you think back all the way kind of to ancient scribes, it was literally written down in some form of text or even hieroglyphics. In 1877, the stenography machine was invented, and that became a new and fast way to capture the spoken word. And if you've ever looked at one of the stenography machines, the keyboards, you probably wondered, how the heck does this machine work? Because none of the keys have letters on them. And it actually takes quite a bit of training and skill to get certified to use one of those machines. And essentially, a stenographer is capturing phonetic notes as they listen to what is said. And those notes are later converted. They're like a form of shorthand. Those notes are later converted into the type of text that you and I would read. And so it's very, very interesting. It hasn't changed for a long time, but now it's changing. And we have some new options that we're going to talk about that can really streamline the way that your firm handles legal testimony. And really what sparked a lot of this is, the shift to going online. COVID-19 changed the way we practice law. It changed a lot of the ways that we think about, work-life balance and work from home and all of it's just had a major impact on our lives in all sorts of ways. But in the legal industry in particular, we've started doing a lot of things online that I think if you think back to 2019 or before, a lot of you probably would have never imagined taking depositions on the computer or attending a court hearing from the comfort of your home desk. It really just was pretty unheard of. I mean, it happened a little bit, but it was a small percentage of the hearings and depositions and other events were taking place online. So it's shifted things, fast forwarded things to embracing technology in a way that I think the legal profession has really never seen. And so COVID kind of forced us, some of us kicking and screaming, some of us embraced it, to rethink the way that we do things. And one of the things that Charles and I are going to talk about today is even though the business of taking depositions went online, as well as doing mediations and court hearings and other things, the business models didn't really change. And so we were still using outdated methods. I don't know how many attorneys I've had tell me, why am I paying a videographer to press record on a Zoom deposition? And so we're going to talk about concepts like that today because we do believe there's a better way to do this. And so I'm going to let Charles kick off. First of all, what is a non-stenographic deposition?
Carl, thank you very much. That's a good introduction. I will tell you that a non-stenographic deposition is just that, a deposition without a stenographer. So it can be audio recorded or video recorded. That's very simple. And I think that that given where we are in technology, these work so well. So let's go on to the next.
And just a real quick story.
Yeah.
I remember the first time someone tried to do a non-stenographic deposition in one of my cases. I was a young lawyer and I was working at Winstead at the time, which is a big Texas firm. And this attorney showed up to the conference rooms. This is back when everything was still in person. And he had his paralegal there and a tripod and a video camera and said, "Okay, I'm ready to get started." And I thought, what in the world is happening? And my initial knee-jerk reaction was, you can't do this. It's just for some reason, my brain was like, no. And he said, well, no, I certainly can do this. And here's the rule. And so I kind of went and looked in the rule book and swallowed my pride a little bit and walked back in and said, okay, it looks like you can do this. So let's talk about the rules a little bit, Charles.
Sure, absolutely. And my experience was much the same, except I was the guy with the tripod. And so I've been doing this for long before COVID, actually, doing non-stenographic video depositions. And I got much the same pushback that Carl, that you experienced and wanted to push back in your deposition. And we're going to talk a little bit about how to grease those skids in a minute. But yes, non-stenographic depositions in certainly in Texas and in the federal rules, absolutely permissible. In 1993, that's a long time ago now, the committee, the advisory committee notes for the federal rules, and the federal rules were changed to allow non-stenographic depositions. And most people today see that in the form of Zoom or video depos. And I'll tell you, because I'm a Texas lawyer, I immediately run to the Texas rules, and I apologize. When you're a hammer, every problem's a nail. That's the way I feel about about Texas. It's also allowed under the Texas rules. So it's the same extent as if you were doing it by stenographic means. So we'll talk a little bit about that. If you talk about the notes that are in the federal rules, I think that's the next group there. The next slide there, Carl.
Yeah, you're going to have to, Charles can't control the slides. I am the slide keeper. So I'm sort of the gig. So you just prompt me, we'll make it as smooth as we can.
Yeah, I wish I had in elementary school, they would say beep, and then we go to the next slide. I'll just say next slide. So
you can beep at me if you want to.
Yeah, fair enough. So really, you can take deposition testimony just as you would with a stenographer non-stenographically. Now, you need to give notice under the rules, and under the federal comments, you have to understand that even if you take a deposition by video means and record it, you still have to be prepared for motion practice, et cetera, to be able to reduce either all or at least a portion of that non-stenographic to a transcript for submission to the court, like, for example, under the dispositive motion.
And Charles, we've had a question, and I think sometimes it's kind of fun to take the questions as they come.
Sure, let's do that.
So I'm actually going to interject because it's kind of spot on with the rules. So the question posted by Shirley is, how receptive are the courts? And I'm going to give my answer, and then Charles, you can tell me if you agree or disagree.
Absolutely.
I think it depends on your jurisdiction and how crystal clear it is. So in federal court, the rules are extremely clear. I'm going to go back one slide. 30B3, testimony may be recorded by audio or audiovisual or stenographic. Texas rules on the screen as well. I won't read it to you. The point there is the rules are very explicit in what they say you can do. And at the core of this, we're going to talk about how to get a transcript, how to work with your video. We're going to talk about all those things. But the fundamental concept here is non-stenographic really typically just means it's a video deposition or an audio deposition, typically video. And most courts, and Scribe has a webpage, and I can share that later in the comments, where every jurisdiction is listed out, almost every jurisdiction. Most states permit it by default, others permit it by stipulation. And so then many are scrambling to try to modernize their rules. There's a shortage of court reporters in California, and they are in a dire situation trying to get their rules changed because they have, according to them, over 1,000 hearings a day that are evidentiary hearings where they're not getting a record because they have some rules in California that prevent them from doing at least hearings with something other than a court reporter. Depositions you can by stipulation. But Charles, in your experience, have the courts been receptive?
I have had, it's a mixed bag. Ultimately, every court where I have made any kind of submission, federal or state, has not pushed back. But I've had lots of lawyers who really aren't familiar with it file objections or push back. But the truth is, at least under Texas and federal and under most states' rules, it's allowed. Here's how to avoid those objections. And if you under Rule 29, and that's the federal rules, stipulations, if you reach a stipulation with the other side, that's the best and easiest way to facilitate the use of non-stenographic depositions. Highly encourage it. Pick up the phone, talk to your opposing counsel, make it happen that way. But what I do typically is I notice a deposition pretty far in advance, at least 30 days in advance if I'm going to do it non-stenographically. And I say in the depo notice, this is going to be non-stenographic. This is how it's going to be taken. Here's who's going to be the notary. If you have an objection, let me know. And if you want to bring your own court reporter, you're welcome to do it at your cost. And in that notice, I've had people object during the middle of a deposition. And I say, well, look, you got the notice 30 days ago, right? And I've had no objection. They go, oh, yeah, okay. That's typically the way I would do it. But the easy way is to pick up the phone, get a stipulation. And so, by the way, under federal and state rules, I want to go on sort of the next thing. The federal rules require an officer and to take the deposition. And I will tell you, the reason why I use and like Scribe is that they will provide an officer to facilitate, to swear in the witness and to do those kinds of things, and act as the officer for the deposition under Texas rules and perhaps under your state rules. The lawyer can do it and act as the officer. For example, I can start the video under the Texas rules, but Scribe or an independent third party can. I've got to be the one that does it because the video is the record in those states and under the federal rules. That's the actual record. So I'm the one that's got to deal with it and keep it safe. Now, I will tell you that that's completely opposite the next one, Carl. Like, for example, under the Louisiana rules. For example, under the Louisiana rules, which is different, they can't be taped by the plaintiff's officer or by the plaintiff's lawyer, personnel, or staff. So just be careful, take a look at your rules, and do it pursuant to your state's rules.
And the other thing that I'll mention really quickly, and I can't speak for Charles, but I can speak for myself. I'm only licensed in the state of Texas. So if I say anything about another state, please make sure you verify that with an attorney that's licensed in that state. Now, I will say that in a couple of the answers, there's been a couple of questions posed that I typed answers to. So if you heard me typing, apologies. But there were some questions about which states don't allow non-stenographic and what are the rules in California. I have answered those questions in the comments with the California rules citation and also a link to Scribe's website where there's a list of each state's codes. Scribe has a 50-state national firm that advises it on every state's admissibility rules and non-stenographic rules. If you have follow-up questions at the end of this presentation, my email address will be there. Charles's email address will be there. We're happy to dig deeper because we're passionate about this topic. But I did just want to give you that caveat. We're not experts in every state, but we are familiar with the rules nationwide. And we also have a firm, Scribe has a firm that we consult with to make sure that all the rules are being addressed properly.
Carl, there was a question about cost, and just to let you know, we're going to come to that. That's a major part of this presentation. So.
Yeah, exactly. Yeah, I left that open because we'll be addressing that shortly. So non-stenographic depositions across the U.S., there's a lot of green. That means full steam ahead. Those states are very receptive to non-stenographic. Typically, in almost all of those states, the rules permit it by default. In federal court, obviously, it is permitted by default, which we've covered. The yellow states are stipulation states, and the red states, to answer the question about which four, based on my latest research, although I can't say for certain whether the scribe team has verified this, those are the four in red where it's not permitted by default or stipulation. I vaguely recall that those may be permitted by court order. So if you have a very cooperative opposing counsel and you're trying to get some discovery stipulations in place, or another place to do it is in your scheduling order. You know, a lot of courts give the parties the leeway to propose a scheduling order, a docket control order, or whatever it may be called in your jurisdiction. You can weave into that agreements about how you're going to streamline discovery, how you're going to try to reduce cost for both sides, and certainly doing depositions in a modern way, such as non-stenographically, remotely, can save clients a lot of money. So, Charles, I know this is something that's near and dear to your heart, so I'll let you hop on your soapbox for a minute.
Yeah, okay, guys. Here we are. So these rules went into effect, the federal rules went into effect in 1993. Technology, as everyone knows, has changed completely since 1993. And frankly, I think that the rules need to be modernized so that it details how transcripts can be done, what the stipulations, if any, need to be, what the conduct of the parties ought to be. And one of the things, I don't know, Carl, if we have this in our presentation, but for example, when we're talking about ethics, who's in the room during the deposition? If you're taking a non-stenographic deposition, a video deposition, are people transmitting answers to the deponent? And those kinds of things, I think, need to be incorporated within the rules. Frankly, I'd love to see a specific notice and how to give a notice put in the rules. I think that would be very helpful. But so it's wide open, especially under the federal rules, so you can still go forward, but it would be really nice to have it cleaned up. Carl?
Yeah, I mean, I agree. I think you hit the nail on the head. The rules certainly could be modernized.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.